Hi, my name's Morgan Leigh. I'm with Scrofano Law PC, and I'm here to talk to you today about protective orders in Maryland. Our firm handles protective orders in Maryland and DC. Today we're going to focus on Maryland. I run the Maryland practice, and we're going to talk about what a protective order is, who can obtain one, why they might obtain one, and what happens once a protective order is issued. Our firm has received an uptick in inquiries for protective orders since the beginning of the pandemic, both from individuals who are seeking help in obtaining a protective order, as well as individuals who are seeking assistance once they've been served with a protective order. Not just anyone can go out and get a protective order against anyone else. A person seeking a protective order is called a petitioner, and the person responding to the protective order is referred to as the respondent. In order to seek a protective order, you have to have a special relationship with the respondent. For example, a current or former girlfriend, cohabitant, current or former spouse, if you have a child in common, if you are related by blood, marriage, or adoption, or if you reside with or are a family member of a vulnerable adult or a minor child. Those are the individuals who can seek a protective order against a respondent in Maryland. Someone who is seeking a protective order may have a variety of reasons for doing so. Some of the common reasons are that the respondent has placed them in fear of something. So, for example, if the respondent has committed an assault or placed you in fear of bodily harm, or has committed an act of abuse against a vulnerable adult or a minor child, committed revenge porn, stalking, harassment. These are all bases for which a petitioner might seek a protective order. So in order to obtain a protective order, the petitioner or the person trying to get the order would go either to the commissioner's office if it's not during business hours, or to the domestic violence clerk if it is business hours. They'll fill out a petition and swear under the penalty of perjury that the information in the petition is true. And then they will give testimony to either a commissioner or a district court judge that will then issue either an interim protective order or a temporary protective order. An interim protective order lasts for 3 days, and that's issued by a commissioner, and a temporary protective order lasts for 7 days. These protective orders can be extended if the respondent is not served with the order in time. Once the respondent is served with the order, then a final protective order hearing is scheduled in the district court of the county where the protective order was filed. At this point, it's really important for both parties to bring all of their evidence. This could be photos, text messages, other witnesses, emails, anything that helps support their case is what they should bring to court. Because at that point, the court is going to determine whether whether the petitioner has shown by a preponderance of the evidence that an act of abuse has been committed by the respondent. What is preponderance of the evidence? That's the standard of proof in a civil case for a protection order. So it's not a criminal case, and most commonly we hear about beyond a reasonable doubt. But that's not the standard for obtaining a protective order. The standard is preponderance of the evidence. That means, is it more likely than not that the respondent committed an act of abuse? We could refer to this as 51%. Does the judge think that it is 51% or more likelihood that the respondent committed an act of abuse? If the answer is yes, then there's a basis for the protective order. So judges have discretion in determining what types of relief to order. It could be anything that is necessary to protect the petitioner. So, for example, a no hostile contact order. Say you want to be able to contact the respondent, but you don't want to be assaulted or threatened. A judge has discretion to order that the respondent not assault or threaten you. You could also request no contact at all. In this case, the respondent would be ordered not to contact you through a third party, email, text, in any way whatsoever. They could order the respondent to vacate a shared residence under certain circumstances, as well as to relinquish or give the petitioner a shared vehicle under certain circumstances. There are also a few different mechanisms for obtaining a final protective order once you get into court. The judge will inform the parties that they have the option of either consenting to the protective order or having a hearing. If you consent to the protective order, then the court does not make a finding either way whether an act of abuse occurred or not, because the respondent agrees to the protective order. If the respondent does not consent, then the court will have a hearing where the evidence will be presented and the court will determine whether there's a basis for a protective order. So while a protective order is a civil proceeding, it can lead to criminal consequences. Once a judge issues a court order against the respondent, if the respondent violates that order, for example, if a judge orders no contact and the respondent continues to send text messages to the petitioner, the respondent could be charged with a criminal offense. For a first offense, it carries a maximum penalty of up to 90 days in jail and or a $1,000 fine. For a second or subsequent offense or violation, that maximum penalty jumps all the way up to a year and or a maximum fine of up to $2,500. There are also a variety of collateral consequences that the parties need to think about when either deciding to consent to a protective order, to get a protective order, or in how to proceed in general. So this can arise when there's a pending custody or divorce dispute, because at this stage, a judge has authority to award temporary visitation or a temporary custody to one party. The respondent also has to relinquish any firearms, and this can be especially problematic if they're a special police officer or they have some sort of job where they have to have a firearm. In addition to that, an employer could find out, there could be issues with security clearances, so there really are a variety of collateral consequences. And so it's important for parties to consult an attorney to determine what the collateral consequences are and how it will affect them. So if you would like more information regarding a protective order in Maryland, click the link in the description in this video or give our office a call, Scrofano Law PC, and we would be happy to provide you with a free consultation to help you understand your rights and options.